Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now this morning I've got a book from Incentio, which is a very interesting book. I think it will appeal to those jurisprudents and those involved with the philosophy of law, and also the general concepts of where we are at the moment as an English legal system and as a continental European legal system. The book is actually entitled European Judicial Systems as a Challenge for Democracy, and it's got a subtitle, European Integration and Democracy Series Volume 3. There are a number of people who've written this book, and I'm going to have a problem immediately with the pronunciation, so please forgive me in advance. They are Elizabeta Kuzaluska, Dariusa Kolsa, Isabella Krasnika, and Franciszek Straziskowski. Now I think I've pronounced those as well as I can, but can I thank all the persons concerned for what is a fascinating read. It's come from the Incentio publishing company based in Cambridge and in Belgium. We've given the title of our written review, that Elizabeth and I talked about this book in some detail. We say it's a book which moves us further along the road to full harmonisation of European law. And I think really that's what the book is offering us. Let's have a quick look. It's a paperback. There it is. There's the front of it. There's the spine. Now there's a lot of learned comments about the book as quotes on the back page, which you can see there. Then inside, it runs to 244 pages. You've got website links right at the back. Then you've got effectively some bibliographical information. There is no index as such with it, so if we go straight to the front, there is the first main page. Then we get into the foreword. Now the foreword is worth reading because it'll give you some indication, I'll mention a bit more about that in a minute, give you some indication of what this book is really about. It's actually then goes straight into a preface, which is a little bit more detailed by the four authors, March 2015. Then you've got the contents section, so it's split into parts 1 and we go on from there to the various other parts there. Sorry, chapters rather, and then the part 2 there, which is from about page 183 onwards. Then there are actually a total of 13 chapters, and each chapter has a bibliography at the end of it, an individual one. So that does, I think, help. Then you've got a list of abbreviations, very important actually with the European dimension, because it's quite often difficult to remember what some of these abbreviations actually stand for. Because there have been some changes. For instance, CJEU is now the Court of Justice of the European Union. For some people who will remember it as the ECJ. So therefore do bear that in mind. It's just one example of little changes that take place. And you see the various parts. The Court of Justice of the European Union. So we get straight into the court itself. Then you can see how the book is structured. It's got a bit of paragraph numbering, and you've got a lot of footnotes, which are quite helpful. A lot of information there. Then just go to the middle of the book again. You've got, as I said, limited paragraph numbering. Then you do have at the end of each chapter the bibliography, which I think is very helpful because this is a learned book. It's got a huge amount of detail in. I think it does go to the heart of some of the issues that we are looking at the moment with what I'm terming the harmonisation of our systems. Now, whether you agree with that or not's a minor matter in some senses, because if you look at it from a practical point of view, for trade, which is where it's coming from initially, it's something that's going to happen whether we like it or not. And in fact, it's a positive. Although some people, of course, will fiercely defend their own legal systems, and rightly too, because there has to be national control over what you do, but there have to be some agreements, and I think that is really where we're moving with this concept of European judicial systems as the challenge for democracy, because the rule of law itself must underpin, I would suggest, everything that we have within our link as the UK member state with the European Union itself and with Europe itself. Enough of the general comments. This is what Elizabeth and I say about the book. What is the role of the European judiciary in the democratic life of continental Europe? And what is its role in the process of European integration? Two questions, fundamental questions for 2015 onwards. Some of the answers, if there are definitive answers then, are to be found in the discussions and research presented in this book for students, academics and academic lawyers, and I think it should be an intriguing read for all. I certainly found it fascinating to go through. Being published by the Belgium-based and increasingly well-known publishing house Intersentia, and the book presents a collection of papers from 17 legal scholars across Europe, which provides a variety of opinions and viewpoints on the various questions posed by European integration and democracy. The focus is primarily on the challenge for democracy posed by European judiciary. In short, the responses by the European judiciary to the problems of modern democracy. And of course, I've added before, added again, the rule of law, because I do believe that underpins everything. Obviously, Magna Carta is our starting point in England and Wales and basically United Kingdom, but we have to consider that in the wider context of what we've given the world by way of our common law itself and the concepts. So, for English lawyers as well as Scottish advocates on this side of the channel, the book certainly provides more than a few insights into the mindset of our continental European counterparts. Quote, "The involvement of the judiciary raises its own wide range of questions concerning the very nature of democracy," say the editors, adding that much ink has been already spilled over issues such as democratic legitimacy, subsidiarity and accountability, the rule of law or judicial activism. Yes, we think we could agree with that. But do remember the words that we now use, which will be unfamiliar to quite a few people. Remember I'm using them again. Democratic legitimacy, subsidiarity and accountability. They are the rules of thumb at the moment, and rightly too. It would appear that full European integration, which presumably requires full harmonisation of European law, is the desired end in view, and I suspect and have done for some time now that is exactly where we are moving. But it's going to take a long time, probably the rest of the 21st century, I would think. But we are moving quite quickly, and you never know how things can change. The process by which all this can be achieved is described, however, as still evolving, and it's also admitted that its final form cannot be predicted. Obviously, that must be the case, but I do think it's probably something that will be needed, and we'll just have to see how events, dear boy, go along. Writing in the foreword, Professor, now I've got an interesting name here, Magic Sapuna, I hope I've pronounced that correctly, Advocate General of the Court of Justice of the European Union, refers to the role of the European judiciary in the ongoing process of European integration, which he says, quote, cannot be overestimated. And I do hope I get this name right, because he's a very important gentleman, Professor Zuzpanar. I think that must be the way it's pronounced. I'm not familiar with the pronunciation. We do owe much, he continues, to the two supreme jurisdictions of Europe, the Court of Justice of the European Union, that's now known as the CJEU, and of course the European Court of Human Rights, which in United Kingdom terms is a controversial court. The expressed aim then of complete European integration may strike terror in any number of British hearts who fear it may end up going in directions which are not to their liking, bearing in mind the evolution of our own legal system over the last 1,000 years. And yes, it has taken that long. 1066 to 21, or in fact 2066 rather, is a very interesting time span. This book, interestingly, provides both reassurance and also a bit of worry regarding the evolution of European democracy, depending on the views expressed. But I think, even not just from a legal point of view, but from an historic perspective, it would be a fascinating read, I think, for many historians. Let me conclude by saying this, because I welcome this book. Lawyers and legal scholars specialising in European law and related issues, that's political, economic and monetary, will derive considerable enlightenment from the fresh and current thinking on European democracy presented in this book. And the publication date is cited as at March 2015. And I'm recording this in the summer of 2015. There's the orange front cover, orange and black, and there's a spine, and there's the back there. Let's just open the book in the middle. In fact, the middle bit is chapter 8, the supremacy of EU law as interpreted by the Polish Constitutional Tribunal. So you've got a wide range of views being put forward there. You see the structure again. It says who's written the particular chapter, an introduction. You've got some classic cases, Costa and ENEL, which is the Wangen and Lewes case, which many of you will know about, which set about very substantial precedent many years ago now. You've then got a whole range of other articles. And I cannot emphasise too strongly how important the development of EU law has been. For instance, we've got chapter 4, towards the democratisation of the EU. Now, there's a lot of talk about this, but I think you've got to make a start somewhere, and that's really where we are at the moment. There are bound to be a lot of problems, but we've got to stick together. There's the contents page again. I'll just show you that just for the last time. There we go, that bit there, and then those two, and then the final bit, which is chapter 13 and the abbreviations. And as I said, there is the one thing which is probably something that would be nice would be to have some sort of index. There isn't, though. You've just got the end of the book there with the standard bibliography and then internet sources right at the end. And they are actually in each of the chapter headings anyway. But the index doesn't exist in it. That's the only thing that is something as an observation. But thank you very much to all concerned. Intercentia have produced a very interesting, thought-provoking book here, and it's something which I'm sure everybody, undergraduates in particular, should read and think about. If you're looking for a first, you need to read books of this nature, so you've got some idea of the much more general picture, historically, politically and legally, as to where we are today. So thank you to all four authors and to Intercentia for an excellent contribution to the debate. Bye-bye.